Intellectual property law and fashion. IP applies to a large part of the fashion industry, and often intellectual property is where the most value of a fashion business is derived. All intellectual property rights could be engaged on a single item. Let's take the example of a piece of footwear. Firstly, copyright is going to protect the initial sketches or drawings of that shoe design. Next, if that piece of footwear features some sort of innovative element, let's say a new cushioning format for the foot, that could be protected as a patent. To the extent that that isn't protectable by way of a patent, it could still be protected as a piece of confidential information and kept secret using a non-disclosure agreement. The overall appearance of a shoe, providing it's sufficiently novel, could then be protected with a registered design. And last, but certainly not least, the brand under which the shoe is sold could be protected as a trademark, both in terms of the word and the associated logos. Understanding each of these different intellectual property rights is crucial, and having a good grasp on when to register them is paramount. For example, patents can only be registered if the invention hasn't been disclosed at all, whereas there's a 12-month grace period to register a registered design. Trademarks also need to be cleared before you produce your shoes. The last thing you want to do is invest in, say, 1,000 pair of shoes featuring your brand name, only to discover that to sell those shoes would amount to a trademark infringement. Fortunately, we're on hand to assist with all of these issues, and our team of solicitors are experts in fashion law.